How many matters are there? 40 and 132. 2 for 3. 3 matters.
Your Lordship, good afternoon.
Yes. ये कौन है?
My name is Samarthya Vishwakarma. I have filed a miscellaneous application 5312. I want to join as a private respondent in the Abhi Naitan case.
What should you? 130.
You filed the application. It is not on record here. You filed
Yeah,
the
I have the diary number right now, 5312. It will be filed.
Okay, then you get it listed. You get it listed there.
Okay.
ठीक है ना? Yes.
This pertains to this result of CGL combined graduate level examination 2024. I filed the away method, and my prayer is not your losses are greatly aware of the dispute not made. Yeah. My prayer will not make is at page 52 of my OA. This is not make Abhi Naitan. Just a brief background will make it. I will go to the crux of the issue.
Yes, 52.
Page 52. I say, where's the impugned result dated 12/3/2025 in Excel table to the extent of exclusion of the names of the applicant? I say that direct the respondents to include the name of the applicants in the final selection list and consequently direct the respondent number 1 to not suitable job to the applicants in terms of their medical practices. And in the alternative, direct crossing of CGL 2024 to the extent of paper 1, section 1 of Tier 2 exam with direction to conduct the same again after giving due. Then there is some inching fair also. When I came to your losses will not be initially issued this, but will not mean there was no direction for state, will not mean I went to High Court says it has to be subject to so and thereafter will not mean I came back to your losses. The OA had been filed below on the grounds, amongst others, that this advertisement will not make 24/6/2024, that is Annexure A3. The clauses thereof will not, conditions thereof will not, this is Annexure A3. It was not followed. This was my submission. I said will not be so far this exam is concerned, Tier 2 exam is concerned. There were two papers, one on 18th January 2025 and another on 20th January 2025.
Tier 1 is separate. You are not questioning the Tier 1.
Tier 1, I am not questioning, the reason being, we were not affected by it. Just a moment.
When I am asking, I am anyways taking note.
So far, Tier 1 is concerned. It's not that it was without any issue. Issues were raised by certain candidates who were affected by it. And ultimately, your losses had passed an order. If the losses may kindly see this volume 2 of by this petition.
So Tier 1 was also questioned, but by other candidates.
1 was questioned and a relief was granted. Volume 2
हाँ, Volume 2 में है ना?
हाँ, Volume 2 देखिए 1026 Annexure A12.
Yes.
1026.
So this OA is also pending.
Is it pending?
Ah.
It is pending, but we lost this actually. Is it pending or is it disposed of?
It is pending, I think.
Your losses had granted interim relief to the applicants. His losses said that you can appear in Tier 2 exam. Pursuant to this is 16th January 25 order. So these people, my lord, who got relief, my lord, they appeared on 18th and 20th, my lord, depending upon whether 6th they will be, my lord, granted. So it's not that tier 1 my lord, was without challenge, it was with challenge, dispatching. You losses granted individually and people appeared in the exam. So when I came to your losses, my lord, I questioned two things. I said after 18th and 20th, 2 exams you conducted, tier 2. 21st, you gave tentative answer key. This is as per advertisement dated 24/6/2020. And at that point of time, my lord, your losses may kindly see the index only. The index of volume 1. See the index, my lord.
Yes.
In Excel A2 is my lord, one notice dated 7/2/2019. This is my lord, about this normalization. This is an accepted thing, no dispute. Advertisement, it says, my lord, if there is multi-shift examination, my lord, there is a possibility that, my lord, students, there can be some variation in marks, my lord. So for the purpose of equalization, my lord, they say this is the way we normalize, this is the mathematical formula. So, my lord, this is not dispute so far, this is concerned. Then after the exam in Excel A4, my lord, as per once again this advertisement, they gave this tentative answer key of, my lord, tier 2 on 21st January 2025. Rule says, my lord, I will show the rules. Rule says that at that stage when you got it, and if you have got any grievances, you approach, my lord, this staff selection commission, they will look into it, and accordingly they will finalize this final, my lord, master answer. I do not know, my lord, who has raised the grievances. I have got no idea. I have brought on record, my lord, this information, my lord, is sought to be obtained under the RTI Act. There is no response to it. There has to be some trigger point, my lord, why the result is required to be modified. I have no answer. They may have the answer, but not I asked in the RTI, but not no response. They said nothing doing. They are not going. So, tick. Yeah. Thereafter, my lord, I brought on record as per this, my lord, tentative answer key, my lord, Excel A5. The marks.
चित्र सहित है।
It is unnecessary noise.
The marks, my lord, that we have obtained. We also said they give some kind of a URL, what they say, my lord. The staff selection commission provides that, look, this is the answer key. You can check that how much marks you are going to get. So we were convinced that we have got substantially higher marks, and we are going to not get into it. At least these people who are before your losses, they did not make any representation that, look, this tentative answer key is wrong, you have to change it. So thereafter, this result came on 12th March 2025. And much thereafter, on 18th of March, they gave the modified answer. We were surprised to see the result. That how is it possible that the persons who has appeared, who has got 324 or even 340 marks, 340 marks or whatever, he was not selected. And person who has got only 299 marks, he is not selected. Normalization could have 18th and 20th 2 exams were there. So for normalization of marks is there. The difference cannot be more than 5 marks. There is a huge gap of 20 marks to 60 marks.
No,
it was impossible.
The result is declared on 12th of March. And how you are saying that a person of 340 marks has not been selected? 340 is your calculation as per the tentative answer key.
As per the, this is their answer key, this is their URL, and this is my calculation, and I have given it.
So at the time of the tentative answer key, you have calculated, you think you should be getting 240, 340.
Answer key, their URL.
And when the final result is you were out, but now you don't know your marks.
No, I got my marks, as per this modified answer key. Modified answer key.
What are your marks now?
No, it has slightly come down.
Oh, obviously it will come down.
It has come down. So that is the situation, and the persons who have got 299, they are into the list, and person who is 340 is out of the list.
That's what I'm trying to understand. 299 as per the tentative.
My lord.
But after normalization and after modification, he has got in.
He is got it.
But a person with after tentative who was at 340, for some reason he has been out.
He is out. So what is that some reason, my lord, that is the most crucial. When I came to your office, I stated.
So there are two things that the marks could have been inflated or deflated due to normalization. You say that if normalization is applied, there will not be a difference of more than 5 marks. So a person 300 and 340 is a huge difference. So the other issue is there may be some questions whose answers are right or wrong or whatever. So now you are not on the normalization, you would be only on the question answer.
Normalization comes later on. Which will ultimately after this master answer key is looked into, it can be decided that how this normalization will be applied. No issue with normalization.
Mr. Counsel, you claim to have got marks like 324, 340 based on the tentative answer key or based on the modified answer key?
Tentative. That is their calculation that they should
But
have.
that is my calculation. They say that this is vague. You have relied upon some rank mitra. Rank mitra is one thing, my lord. Why don't you give me that what is my marks as per the tentative answer key?
So these are based on the tentative answer key.
Tentative answer key.
If you base your marks on the modified answer key, what is your score?
Then they're out.
It has come down.
Just come
Then
down.
you are out of the list.
I am out of the list.
So you are challenging the modified answer key.
I am
The
challenging.
long and
the-
short of this OA is that modified answer key is erroneous and malafide.
No. Malice is there. When I came to your losses, I stated, my lord, that you publish your result on 12th of March. I do not know who objected to, my lord, this tentative answer key. And thereafter, my lord, the result is varied, which is an impossibility even after normalization of 5 marks. I said that you have ultimately selected the persons of your choice and their malice is there. And thereafter, you modified the answer key and you gave it on 18th of March 2025. So there is a bias, my lord, inherent, my lord, in the entire process. When I asked this, my lord, they say that you did not challenge this Tier 1 exam. We have followed the same thing in Tier 1 and you are doing it in Tier 2. This is not possible. My lord, Supreme Court.
Candidates, you can please remove them from the backside of the
Sir,
council.
just let the oxygen flow in the room.
From the pool.
थोड़ा सा side हो जाए. हाँ.
What they are doing here, kindly see them.
Candidates
Sir, it is-
side,
it is
candidates सारे
public
side
court,
पे
sir.
मुझे.
Public court, but they cannot.
Public court में anyone can either subject to your losses.
Candidates थोड़ा side में मुझे. हम लोग इतना वैसे ऊंचा बोलते हैं सबको सुनाई दे.
नहीं तो आपके अनुसार मिस्टर सिन्हा जो टेंटेटिव आंसर की है और जो मॉडिफाइड आंसर की है उसमें क्या अंतर है?
नगर में उसमें ये है कि 22 क्वेश्चन जो इन्होंने किए।
कितने? 22
22
क्वेश्चन का आंसर में 22 क्वेश्चन में डिफरेंस है।
difference है। And when I said, my lord, I pointed out in my OA also that as per the modified answer key, you have made mistakes because these are the government data, these are the NCRT books, these are the things, my lord, which is, my lord, accepted by everybody. So you could not have done it. So that is wrong. So your modified answer key is wrong. You change the result on the basis of this modified answer key, and thereafter you applied this normalization. Sorry, please, sir, please. Thank you.
The permission of the my lord, this is not the modified answer key. It is wrong word which is used is the final result. It is not modified answer key.
The final answer key.
For them,
As
the
per the
tentative
scheme
was
of the
good.
examination.
ठीक है, doesn't matter.
The final answer.
Final answer
Yes.
key. There is a tentative and there is a final answer.
Yes.
तो 22 क्वेश्चंस में अंतर हुआ है।
23.
Additional problem is a change in one answer makes a difference of 4 marks.
Negative marking.
-1 there.
So result will be changed. So once I filed it, my lord, and after brought me all these, my lord, things, they filed their counter affidavit. And in the counter affidavit, my lord, they say at page 24, losses may see the counter affidavit.
वॉल्यूम 2 में है।
In the counter, sir.
Yes, counter assist.
Para 24, my lord, may have page 27.
कह रहा
24, page 27.
Yes.
There is no reference to standardized textbook or prescribed textbooks in the notice dated so and so. And therefore, it is incorrect to assume that certain textbooks have given prescribed or they called standard books. In fact, the only reference in the notice and legal clause is the students have not prescribed any textbook, and therefore, textbooks such as NCRT cannot be the basis for any challenge to opinion of the subject matter experts. Such reliance over textbooks in academic evaluation matters in suppression to answer key treated by experts in the subject has been struck down as had in practice in the following cases. So now, my lord, the dispute, my lord, lies here. What they say, my lord, that they have got their own set of experts. This, my lord, Staff Selection Commission, my lord, it comes under the DOPT. NCRT, my lord, is under Ministry of, my lord, HRD. So what they say, my lord, that these textbooks, these government publications, it has got no bearing. I have, my lord, appointed our own experts. My experts, my lord, read books. I do not know from where, my lord, and from where, my lord, they get information. So whatever information, my lord, their expert is giving, that is correct. And this NCRT, this government, my lord, nothing is binding on them. So this is the nutshell, my lord, of the things that your lordships have to decide.
So, but was this question subjective or objective?
Subjective. Subjective as an adopted question. So sorry.
All objective, no?
All objective.
And based on facts.
Yes, based on facts.
Like I and the member Jay were discussing the other day, if the question is, where is Mongolia located? It's in Asia. Where is Mexico located? It's in the American continent. If the questions are objective and factual, there should not be any difference between the tentative answer key and the final answer key.
Absolutely.
And that you say 23 questions.
23, not 1, not 2, not 3, 20.
Which is quite outrageous.
Yes. That is the thing. And they say that nothing doing. No NCRT, nothing, no government. They are not.
Whether it is NCRT or whether it is CBSE, fact is a fact.
Fact is, but they are not relying upon it. Now, my lord, in this background, my lord, kindly see my rejoinder affidavit. I am straight away, my lord, coming to the point. The reason, my lord, before my lord, I go there, they have also relied upon my lord, one thing.
आप 23 क्वेश्चन बता रहे हैं ना?
23 questions.
11 questions from the 18th generation and 5 questions from the 20th generation.
It is 90 questions. Marks were given to all.
मोबाइल ले जा रहे हो मोबाइल
Three questions. Options were changed.
So let us see the rejoinder. Let us see rejoinder.
Just a moment. But this issue of my lord, whether your lordships have power to intervene, my lord, with their subjective view or their subject expert or not, it is well settled. High Court, my lord, followed the Supreme Court judgments. Supreme Court even lately, my lord, in the case.
We have relied on 3 judge decisions in para 24.
My lord, that's correct, my lord. And my lord, this Staff Selection Commission, my lord, versus Subham Pal, Delhi High Court has given a detailed judgment, and that is the law, my lord, which has been taken to Supreme Court. Supreme Court, my lord, further, my lord,
I'm going to add on to my senior lordships. The previous Shubham Pal also pertains to the SSC issue. Every year there are some issues to the questions and answers. It is not a one-off practice. It's all a model practice.
my submission is, your lordships have the power. There is no dispute. If your lordships want me to read the judgment, my lord, to certain points, I can, my lord, show it to you. If they say, my lord, that your lordships do not have the power, my lord, there cannot be any judicial review so far subject expert is concerned, this is one thing. But in that,
So you wanted to read from the rejoinder.
I wanted to read from the rejoinder only for my lord, one second. This staff selection judgment, my lord, I have also quoted commission. And see paragraph. But my kindly see paragraph. Para 11 onwards. So for the legal issue is concerned, then I will go to the facts. That said, however, it is equally obvious that the sphere of judicial review cannot be altogether foreclosed
You didn't para 12.
Para 11 I am reading.
Okay.
However, it is equally obvious that the sphere of judicial review cannot be altogether foreclosed when such challenges arise. There may be gross cases or cases in which it is evident without any necessity or rationalization or intricate reasoning that the answers under challenge is palpably incorrect. In such case, the interest of substantial justice have to prevail, and students who have attempted the examination cannot be allowed to suffer merely because of an obviously incorrect answer suggested by the subject experts. Now, my lord, may the Supreme, my lord, may High Court courts, my lord, may various Supreme Court judgments, and my lord, may para 12, my lord, may sub Roman 1 onwards. This is the law. And Supreme Court, my lord, may Delhi High Court, my lord, may as well as Supreme Court, my lord, may followed, my lord, may this all these things, my lord, may in this CLAT judgment also. Lately, it was in New Zone. It says 12. I am reading, my lord, may 1 Roman 1. Circumspection is the general rule, especially where experts have considered the objections raised to the answer. I do not know who the experts are. It is, however, equally the rule that there is no absolute prescription against courts examining the challenge to the key answers, even where experts have opined. The law does not commend or even recommend a hands-off approach. In an appropriate case, the court can even examine for itself the correctness of the key answers under challenge, in which process the court is also empowered to refer to authoritative textbook on the subject, especially those which form part of the student's curriculum. Where the question is simple and not admitting of any complexity and can command only one answer, which is apparent to the court is not proscribed from taking a view based on its own perception of the question. To take an extreme example, the sum of 2 and 2, that however would have to be in a rare case in which the answer is so apparent that there can be no doubt about it, and not one where the opinion of someone expertise would help or where there is ambiguity. In any case, the guiding principle is that the general rule against accepting the suggested answer is stands relaxed only where the suggested answer is proved to be wrong, an inferential process of reasoning or rationalization, but clearly and demonstrably wrong in that no reasonable body of men well versed in the subject would regard the key answer as correct. Then, my lord, may the same thing, my lord, may has been repeated here. I am not going, my lord, may into all these things.
Even if there was any lingering doubt as to tribunal's power to differ, especially for multiple choice questions, Delhi High Court and the Supreme Court have multiple times reaffirmed that, especially for MCQ answers, objective answers, courts and tribunals do have the power to intervene. If required, I may.
So, my lord, may power, you lost his power, my lord, may in power of submission, my lord, may as per the Supreme Court and Delhi High Court judgment, my lord, may Delhi High Court is once again based on the Supreme Court. Your losses have the power.
That's the crux of the.
That's the crux of the matter. Your losses can not be broken. Now, before I, my lord, may go to the rejoinder affidavit, if your losses may see my OA, the counts, my lord, may starts from page 11. That is para 5 will not be the coordinate. 5 point Roman 12, page 14 onwards. I have, my lord, may given the list of questions.
Sarah, this is rejoinder.
My lord, may I
File on
am
second
showing from the OA, my lord. I will come to rejoinder immediately. Page 14, my lord, may of the OA. Para 5, my lord, may Roman 12. OA, my lord, may I am saying. Volume 1.
Page 14.
Page 14. So I have given the details of questions, my lord. And the variation in this, my lord, by tentative and modified answer key. There is no response to it, my lord. And
This
this
is a
is,
mathematical question, simplify, this is a algebraic equation.
these type of questions
Reasoning
are here.
also, my lord, reasoning also. The
No, this
statement
has to
of
be
the
objective,
applicant
mathematics is
correct.
objective.
My lord, the statement of the applicant to this extent, they are the geography question on and all that question.
Mathematics is
Correct, my lord,
objective.
mathematic questions and reasoning questions.
My
Also
lord,
there,
may-
my lord.
my lord, my lord, my lord, my lord, may I
There is no
we will come to.
mathematical calculation also required. It's a Pythagorean triplets here. This is the 5, 12, 13. It will be 25, 144 and 169 lordships. Even somebody of class 10 can solve this question, your lordships. This is not a complex a polynomial equation or anything. It is a very simple question. Objective answer, there is only one answer. Similarly, for the other questions also we will demonstrate your lordships.
So in
The
this
math-
question number 2, what is the correct answer as per the initial answer key?
For 1 minute.
Because in maths, you can't be having,
No, there can't
There
be
can
two
be
answers.
some
There can't be.
maths you have to be very
My lord,
objective.
after their counter evidence.
Then the next question, Rani and Adya,
My lord,
is
may
also a
ask-
maths question.
Maths question. When the question pertaining to similar events. Now, my lord, may in this, my lord, may in this background, my lord, if you losses may kindly see my rejoinder ability.
Yes.
The losses, my lord, may on the last date of hearing, he asked me that you prepare a chart showing the questions and tentative and modified answer key and points. So, in Excel A15, page 17 of the rejoinder, my lord. For your losses convenience, my lord, I have made this chart, which is, my lord, may further running page, my lord, may of this, my lord, may, the questions.
You have given the explanation as to
Explanation.
what will be the explanation for your right answer. So the, let's say page 70,
Se- 70.
tentative answer key was 16.8%. Full
My lord.
marks.
My lord.
What does that mean?
Page, now, my lord, may come to page 19.
This is volume 1 or volume 2?
This is the rejoinder. I said I have summarized all these things. You wanted me to give it a chart.
So 22 questions are here.
My lord, may 23.
So you have added one.
Which page in the journal?
Page
My lord, may
17.
page 17 is the chart.
Here.
I have page
So you have given the explanation ki why.
17 and 18 is the chart.
Yes.
For the 19th January, we've given a separate history lordship that is part of the OAS, but I'll complete after.
So this, all these questions are of the,
Both my lord, may 18 and
for
20.
both and 20. ठीक है.
This is the chart, and my lord, may come to page 19 first. First question, my lord, may, this is tentative, my lord, may I have said. According to Census of India 2011, what was the recorded population growth rate of Hindu? The correct answer as per the tentative answer key, my lord, may is 16.8%, and we, my lord, may say this is 16.8%. But once the final, my lord, may or modified, whatever they say, final, let it be final answer key, my lord. It says, according to Census, what are recorded so and so. Says is note, for this question, discrepancy is found in question stroke answer, full marks is being awarded.
So they deleted this.
They say no, they delete this question, give marks to everybody. So my lord, may 3 marks, my lord, may for correct answer, I lost. 1 marks, my lord, may for negative, my lord, may, so my lord, may 4 marks, my lord, may, there is a gap, my lord, arises, my lord, may because of this. Now, why?
One interesting fact. Candidates who have not attended the question, they have also secured this marks, 4 marks.
There are 2 reasons why this is. Number 1, Supreme Court in Guru Nanak, as has been pointed out to your lordships, has specifically said
There is no negative marks.
has
The
specifically
difference
I-
between
I-
that examination
cannot
is
be
that
awarded to
there
all
is no
candidates.
negative
but
marking.
but only to candidates who have attended. This
So,
second thing
yes, so giving the marks to all candidates, whether they've attempted or not attempted also is,
I'm covered by the recent judgment of the Supreme Court, IIT 2017, and my lord has dealt this issue up to the line. I will.
Situation is, situation 18,
There is no negative marking. In IIT 2017 was negative marking.
my lord, may, doesn't matter, my lord, even if negative marking is not there, if I attempted it, my lord, I have given marks. If it is wrong, my lord, may, the entire mark.
It is dealt with by the honorable Supreme Court, my lord.
Just a moment, just have your turn. Just a moment, have your turn.
Just a moment, your lordships. There are 2 reasons why this bonus marks becomes critically important. Within the same day's examination, perhaps there may not be a significant variation in marks on this, but your lordship, the examinations are conducted on 2 different days. Therefore, when bonus marks are awarded to candidates who have not even bothered to read the question, your lordships, in normalization, candidates who spend time, effort during the examination and have attempted this question at the cost of perhaps another question, they are significantly disadvantaged, your lordships. This disadvantage that is caused the candidate who actually spend time in the examination for a question is why Guru Nanak Dev has said the other way, your lordships.
Simple words, what my friend is saying. If a person prefers to answer, do not answer these 22 questions, normal course will get 0. But after this plot way, he will be given 66 marks more. 22 into 3 not equals to 6. So if I did nothing Milot May, I got 66 marks. This is what I intended to say. But Milot May must come to the Milot May, the merit of the thing. Now they say that there is a discrepancy. Page 20 Milot May kindly see. I have given the details. I have said that how these are affecting Milot May the questions. Can ignore Milot May this aspect. Answer details justification kindly see. Page 20 bottom. The correct answer to this question is verifiably of the score 16.8% as supported by official data from the Census of India 2011. According to Census of India 2011, the Hindu population grew from 827 million in 2001, so representing a so this data can be cross-referenced from the official census report published by the Registrar General and Census Commission India. And that I have annexed it here. I have pointed it out. This press information here. This is Government of India data registrar census. It says at the bottom, page 21, 16.8%, Hindus 54.6%. So this is government data. They said no, this is big. So there are answers to the page 22 Milot May kindly see. The same question Milot May was asked in SSC JE Milot. And here once again the correct answer Milot May was 16.8%. Exactly the same question. Same question.
But into the respondents will have changed as per the examination results.
Now there is a change of 4 marks first question. Now Milot May go to page number Milot May 23. Tentative answer key. How many meaningful English words can be formed using first, third, sixth, and seventh letters of the word recognized when counted from left to right using all the letters, but each letter only once in each word? Milot May, the answer is none. Tentative is none. We prefer for none. Now they say in the final answer key it has to be 1. So first, third, seventh, 4 letters are R, C, N, and I. We did all kind of permutation and combination with all. These collaborate mathematics also will not, they have done all permutation combination, and they say that there is no word of English which can be formed with RCNI. There is one word train which is possible, but train is a French word. Page 24.
Not a French derivative word, it is a word in French, not an English.
It's not an English word. The question is English words.
So the tentative answer key said that you can find,
None.
you can make one word.
No, none.
If you can hand over a copy of the dictionary also, you want to say.
Tentative said that no word, but final said one word.
My lord, what is going on? They are handing over the dictionary, my lord.
So we show that.
Oh, we can, will not be the high court can, will not be high.
The case being argued or my lord, something else is going on. My lord, if everything they are lying.
Ajay 639-178 अपना mind
My lord, it should come on record of the court. Everything should be handed over to the court, my lord. What is the practice and procedure, my lord? They are practicing.
I strongly object to it.
Today is the day of that.
I strongly object to it. My friends should not make these kind of statements. If High Court Milord May looks into the dictionary, if Supreme Court looks into the dictionary, 1, 2, 3, 4, into the dictionary, Milord May, even my
These
friend
all
might
books
not
never takes anything on.
If you turn to page, एक second, Mr. Gyanendra, please, this is, I will not allow you to speak. If you turn to page 24, then dictionary is not even required. You have listed out quite a number of the
all these
options.
Milord.
That
This
the
is a
letters which can be,
possibility, Milord.
yeah.
Milord May, this reflects upon Milord May their caliber, that what kind of students are there that have done all these exercises. We have done nothing. We have only. Now, Milord May, he says that I am handing over the dictionary. Bottom 24, bottom I say, whole dictionary which was relied upon by the Honorable High Court SSC, which I am referring to, that I have just told you.
Bhopal has been listed by the Supreme Court.
It is similarly situated.
17/12/2020.
The word being does not appear in the offense.
Mr. Singh,
भाई अपने माइक बंद करो
this way, what, you know what, I have given a special time for this, and that too at the cost of others. Then if you keep on interjecting like this, then we can't proceed further. So if except the council who's arguing, if anyone else, this is a warning to all of you, then I will not proceed any further. That's why I'm saying,
What kind of a thing is
Mr.
this?
Gyanendra, again,
Even in the court martial, Milord May, it's a people's court, anybody can go.
only the arguing
Court can
counsel
regulate.
will speak. All of you will remain silent. We'll give you time, or you make your notes, or give him in slip or whatever. Let him proceed with the rejoinder. I think it will cover everything.
Correct.
Chal.
Now, Milord May, come to the third question at page 27. Now, this is mathematics. The average of first 92 even number is, now 4 options are there, and the correct answer is 93. That's a statistic.
So for this, they have awarded full marks.
Full marks, they
To
say that
everybody.
there is a discrepancy.
Okay.
Now, the issue is, Milord, page 28, Broadway philosophy, may kindly see. What is the average of the first 4 number? Even number. First 4 even number, Broadway is 2, 4, 6, and 8. That is 5. So whenever we calculate Broadway first 4 number, it will be 5. First 4 even number, Broadway average will be 5. The question was first Broadway 92 even numbers, so answer will be 93. Broadway, this is once again Broadway mathematics. Correcting. So here the formula is page 29. Broadway, I have said second, third, fourth, everything I have said. 29 bottom Broadway NCERT book class 6 math chapter 3 playing with number. Page 29.
चलिए ठीक है आगे चलते हैं
क्या आंसर इसका क्या सही आंसर क्या 93
93 is the correct answer.
both in tentative and final.
No, final they say marks to all. This is vague.
वो के हिसाब से कह रही है आंसर बाकी ज्यादा शाम को
The problem is 0. What is 0?
गेट मेन गेट टेस्टिंग जो बालकनी है ना वहां से धूप नहीं आती शाम
अरे
भाई अपने माइक बंद करो भाई माइक बंद करो अपने
12, 14, 16.
भाई अपने माइक बंद करो ना
I say it is vague.
तुम लोग हियरिंग क्यों
This is,
खराब कर रहे हो यार
that is the reason, Milord, why we say we have produced this class 6 NCERT book. It says
नहीं, सभी लोग अपने माइक बंद करो चुपचाप
93
सुनो
is the
यार
right answer. 93 is the right answer.
No, it says that the smallest even number is 2.
Yeah.
So they say that in NCERT they are being taught that the smallest even number is 2. Therefore, 0 cannot be an even number. Therefore, it will be 93.
start with 2
नहीं,
Milord.
चुपचाप रहो अपना माइक बंद करके और हियरिंग सुनो यार
0 with 0 Milord में answer will change.
तो वो 91 तक चला जाएगा.
With 0 Milord में answer will change.
But 0 is not either an even number or odd number.
Milord with the even number.
0 is either
Smallest
odd.
even number is 2.
0 is either odd nor even.
Milord. So page 30 Milord में is the Milord में the class 6 NCERT book. It says which is the smallest even number. Now the same question Page 32, my lord. It was asked, my lord, in staff selection commission itself. Lord. What is the average of first 39 even numbers? Page 32. The formula that I gave, my lord, it has to be, if it is first 39 even, it will be, my lord,
Answer will be
40 is the correct answer. And for first 29 even numbers, correct answer is 30. So this is the way, my lord, it proceeds. My friend is saying कि mathematics की तैयारी करता है. At that point of time, you will office to recollect. This will office not accepting the civil service exam.
तू आ रहा है प्रीलिम्स तो आ ही रहा है. मुझको लग रहा है कि हम प्रीलिम्स में चले जाते हैं. अभी जाइए हम भी जाते हैं. इस इतवार को प्रीलिम्स एग्जाम है. हमने जज नहीं दिया है.
If the losses will recollect at that point of time, Lord, they know everything under the sun. At least at that age, Lord. This is the level of the preparation, Lord, at that point of time. If the losses tell me to give, Lord, the answer to all these things, I won't be able to do it. I made a request to them that please you do all these things. So they did the exercise and I have just.
So basically now from the rejoinder, we can gather that for each and every question which you have placed a doubt on, you have given an explanation.
Explanation, Lord, may supported by government data, NCRT books,
Yes.
etc.
So now all the under the examination, there is no chance to you to give these point out the problems with the final key. This is a problem with the final answer key.
Final answer.
There is no chance afforded to the candidates who have now been ousted to.
That's correct.
Yes. So now that it has been raised, you have seen the rejoinder. So what is your stand? Only simply to these questions.
Just a moment. I backed up all these things in my OA also. There is no response in the counter, but for the fact, look what NCRT, we don't believe in any NCRT. We have our experts.
Okay, no, because see some of the questions, let's say चलिए वो maths वाला छोड़ भी दे, but then वो percentage वाला है, the census वाला. There is a proper advertisement on that.
There is official data.
You can't be just brushing aside. I'm sure if I go through each and every question, 2, 4, 5, not 22, 23 नहीं मानो. 4 or 5 questions will be there. For which even you, for example, that RCIN wala.
Yes.
You can't say that.
This is
So
not
therefore,
time.
this is a time where the SSC should introspect and see that if any mistake has occurred with the final answer key, they should again verify that.
I would first of all, how the answer key is prepared and get even final answer key. I am giving the.
That you have argued on the earlier occasion, and now we are not. He has very smartly left that point today, on which we noted in the first. That is how the timeline that the officers were called, and they have explained, adequately explained, that the timeline between the result and the final answer. Because that was the process they had followed in tier 1. They have been following earlier exams also, and one of the officers who came, he said, "Oh, in the next notification, you will see a note also because there is a little bit of a problem with the." So that point we are not touching. Now the point is regarding these 23 questions, because some of them, even looking at the basic English, some basic mathematics, some of them we also find that giving marks to all candidates is actually awarding people who are actually not deserving.
Yes, ma'am.
And this way, you as a SSC, your motto should be that we have to select the person who's most deserving. And it's after all a competitive examination. So what we would, at least I would feel that after the rejoinder has been filed, the SSC should have actually looked at these questions and then come up with the final.
Post restoration. For that reason, when I was importing Muchi on them, I said if 21st, not by January 2025, you get the tentative answer. If we are satisfied to, these are the marks, we will get it. We may not get it as different. If the variation in result is there, and thereafter on 18th March, they say that we follow the same principle because we followed this in the prelim. I have one example. My submission is where it is written in this advertisement that you have to give this final answer key only after the result is published. It says that if you have any objection, you point it out to them, and thereafter their decision will be final. So who pointed out? So far, this tentative answer is
So who raised, because there are lakhs of candidates who have applied and have participated. So there few hundreds are here. So we don't know across the country how many have given their objections to the tentative answer.
They have not stated, and this I said, my lord, may even in my this RTI application that you the questions, the objections that were raised after this tentative answer key, they said we will not give it. That is the reason I am saying they have selected the candidates. Now they have to show that how they are selected.
That theory is a little far-fetched because
I am constant that it is.
we don't credit them with that kind of intelligence or mathematical or algorithm or that kind of machinery to pick and choose and then to modify the result in a manner that their chosen people come in. It's an extreme. So it's one for a smaller exam interview perhaps, but this kind of a huge exercise they can't do that. But yes, about the 23 questions, that is one in my mind that
yes, we are ultimately zeroing in ourselves, restricting ourselves.
the rest of the grounds.
So, so far this is concerned, it is in the.
So their only difference that yes, we have an expert team, and that expert team has
भाई लाउड स्पीकर बंद कर लो यार, क्यों बोल लो बीच में?
Show these 23 questions to your expert team.
Kindly appreciate that.
And let us have their reasoning vis-a-vis challenge to these 23 answers with their reasoning.
When this tentative answer key, was prepared, I am supporting my friend. Everything is done by the experts and nothing is done by the staff. So once this questions were set and tentative answer key was prepared, it was once again their experts. Nobody else was there. So now another set of experts they brought and they said that you modify it. And they said, no, let us change the mathematics. Where is the problem?
This issue has already been dealt by more than 1,000 judgments by this court, High Court and the Supreme Court, my lord. And my lord, one another type of argument, my lord, on which I am relying upon, my lord. I am covered by the order and judgment passed by the Honorable Court in C. Girja Vyas case, my lord. I am just handing over the copy of that judgment. A person who has applied for the examination after going through the scheme of the examination and contents of the advertisement,
they are not.
Participated.
वो चीजें खत्म हो गई. नहीं, Mr. Gyanand, you read para 10.
Lord, I am not.
I am only reading para 10 of this document. 10 and 11 पढ़िए.
It is stated by the Honorable Supreme Court. It is stated by the Honorable Supreme Court. 17th December 2024. SLP number I am giving. I am giving the SLP number. Applicant relying upon the law.
Supreme Court has stated what, my lord? The
Supreme Court has stated the order and judgment passed by the Honorable High Court. While SLP Civil Diary number 55798 of 2024. Why this order dated 17/12 of 2024? Now, in terms of the order passed by the Honorable Supreme Court, this is not a good law for time being. My respectful submission is that the argument on which the applicant is relying upon of this Subhampal is no longer good law for time being. So this argument of the applicant does not come any help for the applicant. I will supply the copy of it now.
ठीक है, we believe you.
What my learned friend has submitted, that is absolutely correct. This stay order was passed in a different context. Some programs for it.
My lord, I am sorry.
No, just group of students didn't challenge that question earlier. So giving liberty to those group of students, Supreme Court has stated this.
The Supreme Court has been held by the Staff Selection Commission.
Point is the stay is there, so we don't know what will be the final. Actually, that is one aspect. Now there are other judgments also which you are relying on. So now the issue boils down to what is to be done with respect to 22 plus 1 question 23.
Yes, what I am submitting. What my friend is saying, if I understood it correctly, that if I have participated in the exam, I do not have a right to challenge the exam.
Yes. This court has recorded findings to 3 questions to say that the answer key is used for correcting the question paper used one single correct answer. The alternative options cannot be unambiguously clear answers. For which
Acha, this is one. Now there is one CLAT judgment which
Yes,
has
sir.
come Supreme Court. They have, I think, given these similar directions.
Similar direction. I'm so sorry, I have not the Supreme Court the two copies. This is correct, but really I would. Really I should have.
See, Supreme Court में हो गया ना CLAT का अभी pending है.
अभी हुआ था, उन्होंने डायरेक्शन दिया था.
इनफैक्ट क्या हुआ था कि दिल्ली हाई कोर्ट ने डायरेक्शन दिया था. सुप्रीम कोर्ट हैज गॉन वन स्टेप फर्दर. You said that you will include these 2 questions
Also further more.
Delhi High Court order number 2.
This is Shivraj Sharma.
Shivraj Sharma and the High Court. It goes to Supreme Court also.
Yes.
Citizen declared the High Court, Supreme Court.
Let's read the High Court question.
कौन सा पैरा है?
My lord, so far High Court is concerned. My lord, from para 2, just to have a background. First, see, the Delhi High Court. The admission notification for common law admission test /2025 was issued by the respondent consortium inviting applications for admission to undergraduate program leading to award of BA, LLB or BCom. The petitioners submitted their online application seeking admission to 5 their integrated law programs conducted by NLUs. The entrance examination was scheduled on 1/12/2024, wherein the petitioners appeared when assigned. Was entrance examination scheduled on so when the petitioners appeared and were assigned different sets of out of the 4 set questions paper set A, B, C, and D. The question paper comprised of 120 questions, wherein 1 mark was to be awarded for the every correct answer and 0.25 marks to every correct answer. Now all these things has been said. It says para 5. Before adverting to the facts of each LPA and petition, it would be apposite to consider the loss of important basis of this court in respect of the principles would the red court intervene and examine the correctness of such provisions of final answer key and extent thereof. In this context, it will be pertinent to extend and Vijay Singh, Lord May, my friend is relying on Lord May staff selection commission that I then Lord May Salil Maheshwari friend just came. Now Lord May see Lord May how the High Court has approached para 6, para 7.
So that they have discussed each question and then asked.
2 questions, my lord.
So 3 questions by the High Court and 2 were added by the Supreme Court. Supreme Court has said anything about the power and by the Red Court to actually direct or go into this behind the expert opinion?
Yes. It has been reaffirmed. 2 more questions have been added. So this is the long and short of it.
The earlier submission has made specifically for multiple choice questions. One CLAT is of course a multiple choice questions.
What the Supreme Court judgment?
The academician
Even the revised result has been declared by the CLAT. Even the revised result has been declared.
Now that goes without saying in the sense because the High Court has said it is subject to outcome of the way. Then ultimately will not be subject to outcome of the way, will not be the entire result to be revised if need be.
Hand over a copy of DPS Chawla where the High Court has dealt with this extensively. If you may just take out one paragraph in issues. DPS Chawla. Paragraph 18, your lordships. In multiple choice questions, the examiner / evaluator strictly speaking, is left with no role whatsoever. And in fact, most of the examinations with multiple choice questions have not substituted the examiners evaluators with an OMR. Thus, the rule prohibiting re-evaluation framed with respect to the essay type answers cannot be said to be applicable to the answer to multiple choice questions. That is paragraph 15. Then in paragraph 18, in the present case, we find injustice to have been meted out to the petitioner. Instead of being declared successful, owing to the mistake/error of the respondents themselves, he has been declared unsuccessful. This court, in exercise of powers of judicial review, is not called upon to undertake any exercise of reappreciation of the answer, but only to correct the obvious mistakes. As my learned senior has pointed out, Your Lordship, these are very obvious mistakes. The census says a number, the number is that number. The SSC in different examinations says that number is the correct answer. If Your Lordship would grant us some time, we'd explain each questioner as to why their answers are incorrect, Your Lordships. But the law is clear. There is no question as to the law, especially on multiple choice answer questions. We are therefore the opinion of the power cannot be denied in such cases. Paragraph 18.
Which were the two questions which were added by the Honorable Supreme Court in the CLAT exam? They're mentioned in the judgment.
It is mentioned.
Which questions are those?
Last 5 paragraphs.
116, this Gujarat, Goa, Kerala, Jharkhand.
One is without made.
Shubham Pal, single bench judgment is there?
Unfortunately, it's a copy. Get a copy.
The 22-23 questions, according to you, the tentative answer key was correct for all? So they can, so that is one.
इनको क्या वो डाउट जैसे हमने पढ़ा भी इतिहास का क्वेश्चन था कि गांधी जी ने अपना सत्याग्रह किस सन में शुरू किया 1918, 1917, 1916. अब हर हिस्ट्री किताब में लिखा हुआ कि 1918 में शुरू हुआ था, अहमदाबाद मिल स्ट्राइक हुई थी. अब उसमें आपको पता नहीं जो एक्सपर्ट्स थे जिन्होंने बनाया था फाइनल आंसर की उनको डाउट आ गया, उन्होंने कहा ये वेग है तो उसको सबको इक्वल नंबर दे दो. जबकि फैक्ट है कि
मैथमेटिकल रीजनिंग क्वेश्चंस
एक क्वेश्चन है इसमें मैंने देखा है सत्याग्रह मूवमेंट कब शुरू किया था गांधी जी ने, उसमें करेक्ट आंसर है टेंटेटिव आंसर की में 1918. बाद में भी उन्होंने कहा कि कुछ डाउट आ गया हमारे मन में. अब इट्स अ हिस्टोरिकल फैक्ट. अब सेंसस का जैसे आप जाइए इस वेबसाइट पे सेंसस कमिश्नर रजिस्टर जनरल ऑफ इंडिया, वो बताएगा कि हिंदू रेट ऑफ ग्रोथ कितना था. इट्स अ इररिफ्यूटेबल इंडिस्प्यूटेबल फैक्ट. तो ये हम पूछना चाहते हैं, तभी हमने बुलाया भी था. आप पहले भी आ चुके हैं स्टाफ सिलेक्शन कमीशन से. कंट्रोल ऑफ एग्जामिनेशन है ना आप, तो डिप्टी सेक्रेटरी. कंट्रोल एग्जामिनेशन कौन है इसमें? जैसे संडे को यूपीएससी का एग्जाम हो रहा है, 15 लाख बच्चे परीक्षा देंगे प्रीलिम्स का, उसमें अगर ऐसे 22-23 क्वेश्चन निकल गए तो क्या होगा?
This issue has been dealt by the Supreme Court, my lord. This issue has been dealt by the Supreme Court.
ये आप
I'm giving the judgment, my lord.
एक अभी आप ऐसे मत दे, पहले let them complete then we'll take. हाँ, और कुछ और जजमेंट?
So far the questions are concerned, Lord, when do I have to follow your office each and every question?
हमने देख लिया था वो आगे. मैथ्स का तो वो जो algebraic है वो तो I think it has to be only one answer. Y और Z का जो algebra question है.
Even Lord,
I think I was joking with my sister that I think we should not become controller examinations and become experts.
Unfortunately, the court has not made do this job.
But I think why should we? In UPSC we never interfere. It's only DSSS and in the Staff Selection Commission that we are constrained to interfere. We don't want to interfere. Why should we? You do your job meticulously, punctiliously, and flawlessly. Why should we interfere?
It is happening every year.
This is the one side of the argument.
Wait for your turn. We are only.
Submission is ultimately, if this 23 question 22 I have raised in my petition, if ultimately this tentative answer key is accepted as correct but not matched for all this, the entire result will have to be revised. Thereafter, they can apply this normalization principles, no issue. I'm not questioning that. First, they have to change my lord, may things the tentative, they have to accept it and they have to.
But haven't the horses bolted from the stable? I'm told that they have given some. They have given some appointment letters also.
That is the reason. That is the reason. When I went to High Court said it has to be subject to outcome. And they have published everywhere. So ultimately, what happened in Bengal case was the entire recruiter teachers for 20-30,000 for the Supreme Court scrapped. High Court scrapped it for Bengal government came to Supreme Court just 3%. So here the situation is the same. If you also see the High Court order when I went to High Court, maybe you also pointed out that there will be certain candidates who are in different jobs. They will resign those jobs, come here, and ultimately, if you lost this revised result, which has to be because of the kind of the answer they have changed. So they will lose even the first job, and they will lose this also. So High Court was conscious of all these things. So High Court says this is for final disposal will not be. So High Court said that it is subject to outcome.
इस पे High Court order की भी copy जॉइंट में लगाई है आपने?
इसमें फाइल में लगेगी in 1.05 to the
in one other file it could be there.
1405 much honey.
OA number 1408 also.
Annexure 8 and at page 261 is
ठीक है कोई बात
इसकी फाइल में रखा हुआ है.
So the petition number is
ठीक है, that's okay. चलिए now there are 22. There is one additional point you wanted to give.
Yes. Days है total days.
Points आपके सारे आगे arguments आ गए. एक argument extra है ना किसी की? हाँ.
Additional issue was regarding computer examination, which was scheduled to be held on 18th of January. And it was rescheduled for 31st. Candidates were sent across India. Candidate who is from Ghaziabad, he was sent to South. South Indian candidate was sent here. Nearly 23,000 students missed that examination.
For the reason, they saw this tentative answer key on 21st. They said, look, we are out. Why should we go and write somewhere in southern part of the country? They said the computer exam. So 20 or 25,000,
23,000 approximately.
They missed this exam. Because they went by the tentative answer key, they did not.
So they were not good even in the tentative.
Even in the tentative.
So
they went by the tentative, and when they changed that, they look the computer exam, they have to be old later on.
But then that point is not, because now it is only for the final answer. Because if they had were aggrieved of the short time between 15 January to 31st January, they would have come during that. So that additional point will not have much weightage.
Yes, read over a copy of other Supreme Court judgment. On this point of fact, till what point can this power be exercised? If I may invite your attention to paragraph 11 of this judgment, this is again a 2005 Supreme Court judgment.
So this point of computer-based exam has been raised in this student? OA number?
1408.
1408.
So these candidates are not aggrieved by that.
And neither.
They are simply pointing.
So 1408 applicants are those who did not sit for the computer-based exam.
They have pointed out.
They have simply pointed out that there was too lesser time and therefore 20,000 candidates did not appear. So therefore, those who have finally lucky are facing less competition. This is what you want to drive.
What we are saying is, it will affect the normalization process.
My lord, it will affect the normalization process. This is what we are saying.
Leadership. Normalization is what if the total average mark of 18 and average mark of 28 is taken. That is the way if these people are out,
but then this is but this is a regular matter for every selection, because ठीक है इसमें 20,000 नहीं आए हैं, किसी में 10,000 नहीं आएंगे, किसी में 15,000, किसी में 5,000 नहीं आएंगे. So this happens every year. So
notification was given well within the time to
we are not going on.
the applicant who did who is not present in the exam.
No, therefore. अच्छा एक predict. Yes. What is this judgment now?
Manish Ujjwal, Lordship, paragraph 11, 2005 Supreme Court decision.
What is the point on this?
Lordship, at any point in time, courts can interfere and direct re-evaluation based on the correct answer. In this, Lordship, we direct re-evaluation of all the questions by feeding correct answers. Our challenge is that the final answers had incorrect answers. We direct re-evaluation of all the questions by feeding correct answers as above noticed. And on that basis, correct number of marks obtained by all students should be assigned and their ranking prepared. So, fresh list ought to be prepared.
Which paragraph?
Paragraph 11, you not like.
11.
Yes.
The second movie
The second
director.
person, that paragraph. Observations also made saying by the problematic.
So, but power is concerned is when power is sufficient, you also have the power. Now, what is to be done? So, for these 23 questions are concerned, we have given the examples, the comment report, etc., etc., etc. There is no response from the side. Wait and wait. So, you also have to return a finding that these answers have to be the tentative results should be declared as per the tentative answer. So, there are the variations. Because if you losses leave it once again upon the expert, it will go into circles and circles.
So we have to declare the correct answers.
What is the meaning of the tentative answer key? If my lord, there is no meaning, my lord, of the final.
ठीक है. Okay.
See, logic requires to go to the individual questions because there are serious issues and other questions also which form part of the 23.
So let us hear the respondents on the question of power, because their main contention is in their counter that they have their experts and we are not the field experts and we don't have the power to entertain these kind of questions. इस पे judgment.
I will kindly come to page 59 of my counter. We start, my lord, and if there are one page 46.
Page 49
Page 46, my lord, and if there are
of the counters.
Yes, my lord.
See the judgment. They find. They find.
Page 46.
The first judgment, Mahesh Kumar.
Mahesh Kumar finally had para 2. Para 2. Petitioner had filed the royal proceeding. The petitioner applied for combined level examination 2017 under the unreserved and orthopedically effort category as per the result of that examination dated 15 November 2019. The petitioner was selected for the post of auditor department officer. However, as per the post defense opted by the petitioner had the period of the computer-based model 100 qualifying marks as per the category, he would have become eligible for the post of inspector. The computer-based examination comprised of 3 modules: word processing, speech, sheet, and sensation of slides. Being not satisfied with the result of the petitioner filed the WPD number, which on objection being taken by the respondent is maintainability, therefore the alternative remedy that being available was not passed by order to the representation of the petitioner directly to decide with body. This said representation was disposed of 22nd July 2020, stating that the petitioner had secured 97 marks in CPT, having scored 35 marks, model 2 and 62 marks in model 3. The cutoff in the model 2 and 6 was 600 marks for the category. Now, since the petitioner did not secure the cutoff mark, he was declared not qualified in CPT and ineligible for certain category of what the petitioner had requested for re-evaluation of the answer script of CPT. The petitioner white data dated this. Now, my lord, I may draw the attention at page number 14. This is the active position of the case. Para 4, my lord.
Para 6.
Para 4.
We have heard the counsel of the
We
petitioner.
heard the counsel for the petitioner. We heard whether the petitioner wants us to do is to educate whether the evaluation of the answer script of CPT taken by the petitioner as part of the combined level examination 2017 in order or not, whether the evaluation thereof in order or not, and whether the petitioner CPT is entitled to any marks in excess 97 marks related by the examining authority. Only subject expert and pursue the evaluation of the answer script not only of the petitioner but of all other similarly placed as petitioner. The same is not in the domain of the court or jurisdiction under Article 226 of Constitution of India. We have no expertise. Evaluation of the result of an examination list of the CPT Even in a subject like law, in which judges can claim to have knowledge, Karna Verma versus Registrar General of High Court of Punjab and Haryana reported this, relying on HP Public Service Commission versus Upesh Thakur and Pramod Kumar Srivastava versus Bihar Public Service Commission. It has been held that court cannot take upon itself the evaluation of the answer given by a participant for the direct evaluation of an independent committee. Moreover, the answer scripts of all examinees are to be examined objectively and preferably by the same examiner, or even if by the different examiner, by the following the same criteria. It is not the case of the petitioner that there is any flaw in the evaluation of the answer script of all candidates who could be the score could not be justified in, even if it is possible for the court to examine, evaluate the answer scripts to examine, evaluate the answer script of the petitioner only, and which is directly projecting disparity and often the floodgates with all others who may also not qualified in use their answer script also to be evaluated by the court. The counsel for the petitioner has referred. Now come to para 8. Para 8. The challenge in the aforesaid case was in the entire examination as distinct from the challenge in the petition only to the evaluation of the answer script of the petitioner, as after the aforesaid judgment, Supreme Court has repeatedly in Central Board of Secondary Education versus Putru Srivastava, Ran Vijay Singh versus State of Uttar Pradesh, High Court of Tripura versus Tirath Sarthi Mukherjee, Bihar Staff Selection Commission versus Arun Kumar, Vikesh Kumar Gupta versus State of Rajasthan, held that in absence of any provision for the evaluation of the answer book in the relevant rules, no candidate in an examination has any right to claim or ask the evaluation of his marks, and the court may permit the evaluation or to be only to be demonstrated very clearly without any intensive process of reasoning or by process of rationalization, and only a rare or exception cases. It was further added that the court should not be evaluated or scrutinize the answer sheets of the candidate as the court has no expertise in the matter, and academic matters are left to the left to academics. It was that further held that court presume the correctness of the evaluation and proceed on that assumption that in the event of the doubt, then go to the examination authority there rather than to the came to be dismissed. Now this challenge before the Honorable Supreme Court, now page 53, my lord. The Supreme Court has upheld the order and judgment passed by the my lord. Page number 54. Maharashtra State Board of
इसका पैरा नंबर बता दे बस. She'll go through the पैरा number. You don't need to read.
Para number minus page 57, para 30. Page 2, page 57, para 2.2 and 32. 3.1, 3.2.
57.
Now, I know that we seeking permission of the Honorable Court to draw the attention of one more element.
Run Vijay next. No. Next over here, Run Vijay.
That is the Ran Vijay Singh, my lord. It is running. They are also taking the center of this judgment, and I am also my lord. That is 8-0, my lord. NHL R4. I don't finally come to para 6. Another batch of writ para 6 of page 81. Another batch of writ petitions having 77 writ petitioners came to the district before another learned single judge of High Court. The subject and district were the same, and the learned single judge admitted the activity for final hearing, not to the dismissal of several similar petitions. The challenge made by the writ petition provided to 7 questions answers in the written examination, which according to them had correct. He answered. The learned single judge personally examined those given questions and concluded that the correct answer of question number 24 in history paper would be option 1. For question number 25 in history paper, option 2 is correct. Option is correct answer for question number 36 of history paper. Option correct answer in respect of question number 37 of history paper. Question number 40 of history paper is wrongly framed. In question number 40, there may be 2 correct answers, option 1 and 3. In paper, option 3.
अरे माइक बंद कर ले अपना शौकीनदार.
Then proceed at to observe. It cannot be doubted that the being a selection body of appointment of teachers in the secondary school or as well as the history of religion hold selection very carefully, meticulously, and the most honest manner the law of selection board should selection without caring whether examination is being conducted correctly and properly.
गाइस नेम नोट कर लो इनका जो भी न्यूसेंस क्रिएट कर रहे हैं ना ड्यूरिंग हियरिंग नेम नोट कर लो बस इनका आप लोग मैं कोर्ट मास्टर सर से बात करूंगा आप नेम नोट कर लीजिए इनके बस
It causes a multi-age injury to the otherwise studious intelligent student who understand the subject well or relevant details and correct answer suffered the pushing negligence of the examining body. The obligation of examining body cannot be allowed to white out, witting out in the any manner for any reason whatsoever or the cannot be made on the basis of the learned changes. Thereafter, my lord, this matter came up for my lord.
Yes,
Para 10.
Para 10,
my lord.
He should read 8 also.
Being agreed by the decision of the judge, the board prepared a special appeal division bench of the High Court. Some candidates are directed against the judgment stating this.
नीचे माइक का ऑप्शन है उसको बंद कर दो सब लोग
Dismissed by the division bench of the High Court and some other special appeal by the board. 14 September 2010 for now declared unsuccessful. Therefore, set of
भाई माइक बंद करो सब अपना हियरिंग सुनने दो
those agreed by the division bench who filed the petition. Now, my lord, kindly come to page 90, my lord, 90. As a result of discussion and taking consideration all of the possibilities that might arise, we issue the following letter. Result prepared by the board consulted upon the decision taken. This High Court should be declared by the board within 2 weeks from today. Candidates appointed and working trained deputy teachers pursuant to the declaration of result on letter of occasion found unacceptable on third declaration of it should not be moved. Page number 15. Under the circumstances, this court is not inclined to interfere in the instant petition. Accordingly, it is dismissed. Now, second petition, my lord, Samarthya petition. Samarthya petition is like in the similar fashion, my lord, same question and everything is raised by the applicant and the kindly come to page 132. Support that, my lord, 130. Para 12, having heard the my lord, page 130. Having heard the party, this court is obvious that essential outcome is scope of court interference with the result of the examination. The Supreme Court in
Vijay is being followed.
Now, my lord, in another case, High Court of Tripura versus I just relied upon, and thereafter, my lord, this petition is also dismissed. Now, my lord, LPA by the Honorable High Court. In the High Court of Delhi at New Delhi, this is the National Board of Examination. Come to my lord, page 136. My lord has pointed out how can it be wrong, my lord, if census is giving the data on the. So, my lord, this is the answer of the my lord queries at page number 136. The SRS stated that the information is provided by them for all the 4 choices: birth rate, death rate, maternal mortality rate, and infant mortality rate. On the basis of this, the learned single just pronounced the improvement date. When WC was partly allowed, the following direction was given. Now, para 4. The learned senior counsel argued that the incorrect question was not such that it would require judicial intervention and that learned senior judge approach in awarding 1 mark to all candidates in technical law as the court must exercise their power within a limited scope of judicial review in academic matter. He stated that the UP Public Service Commission versus Rahul Singh, the Supreme Court has observed that when it came to the conflict use with regard to the answer in an exam, then the court must go down to the opinion of the expert and cannot take on the role of the expert in academic matter. The learned senior counsel further stated that the instant case, the learned senior judge had erred by calling for an affidavit on behalf of the Registrar General of Census Commissioner when he had no jurisdiction to propose, and that no consent had been sought from the applicant. Hearing before the said decision was taken. Sri learned senior counsel appearing for the applicant in Rojgaar for the appellant side Savan Vijay Singh.
ठीक है तन्मय again आ गया ठीक है next.
Now my lord, come to para 13.141. The scope I would have
ये
141. The scope of judicial review may be the scope of judicial review when it comes to the correctness of the answer has been considered time and again by the Honorable Supreme Court, wherein no man has been to entertain such challenge on a very limited ground and give due weight to the opinions of the subject.
ठीक है the LP has been allowed. चलिए.
Now my para 14. Para 15 my lord आ गया फिर. Now para 16. My lord have take note of the same and my lord appeal is allowed. Para 16. Now my lord one more judgment by the Honorable High Court of Delhi in Freya Kothari versus Union of India. The same issue came up for consideration before the my lord and my lord was given one more judgment my lord passed by the Honorable Supreme Court. I am just handing over the copy of said to you.
Yes, इसके कौन से पैरल हैं?
My lord kindly come to para 1, page number 2. For the sake of convenience and clarity, we are of the taking fact. This is the my lord case Balram Vishnu Subramani versus Union of India. For the sake of the convenience and clarity, we are taking fact from the registration number. This registration has paid for determined amount. Calling for the report relating to wide answer T for the JE Advance 2017 examination published by the second respondent in their official website and set aside the same insofar the awarding plus 3 marks to all candidates in chemistry question number 29, code 1 paper 1 and plus 4 marks to all candidates in mathematics question number 39 in code 1 paper 1 and 2. All the corresponding questions in all codes 0 to 9 and further to issue a writ of mandamus commanding the respondent to revoke the 7 marks awarded to the candidates of JEE Advanced 2017 whose question papers were printed correctly and they had not attempted the question and award negative marks in applicability those attempted wrongly and to publish the result of JEE Advanced 2017 and further direct the respondent to publish the revised All India ranking list. It is contended that the petition certain questions were held erroneously, yet it had correct answer and some student has given the appropriate answer. It is urged that the respondent number 2 in an arbitrary manner decided to grant the requisite marks, that is 18 to all of the candidates, because the expert body held that the mistake could be best remedied in the said manner in the counter affidavit. It is averred that the respondent number 2 discovered printing inconsistency.
But they have expressed their anguish.
Yes, my lord. Now, ma'am, kindly come to my lord, page number 5 and 4th para. At this juncture, learning additional now, my lord, the issue awarding this once. So now,
you
my
are
lord,
also from
my
the
lord,
pocket side.
I am from the respondent. My lord,
Yes. Give him also a chance. Yes.
Since I appear in OA 1408, my counter is not filed. I will only make submissions which are obvious from the application and from a common man's point of view.
Any new submission which is not been
Yes,
made by
because I will. When the judicial interference in respect to a subject expert's opinion is concerned, a distinction has to be drawn from what is something which is error on the apparent of apparent on the face of the record, or something which is a mistake of it that very clearly, and something a question which is so vague that in an exam where lakhs of students appear, those students, multiple conclusions are arrived at by different students so as to create a confusion in their minds. Therefore, my lords, I will only make submissions from the record only. If my lords have the rejoinder, For example, the question, according to census of 2011, what was the recorded population growth rate of Hindu religion? My counter is not on record. I don't know what weight with the subject matters, but I as a layman applied my logic to my mind to this question, and I thought what objection I can raise to this question. Because the very first objection I will raise in comparison to what? Growth rate in comparison to what? Because it says according to census of 2011, what was the recorded population growth rate of Hindu population? Now, that growth rate has to be in comparison of some year. Therefore, it's the beginning year and the ending year between which the growth rate has to be compared. Both years are not mentioned. Therefore, some student may perceive it to be an annual growth, some may perceive it to a 10-year growth, some may perceive it to be a 30-year growth.
So basically, what
it's a big question.
Should say you should employ the experts to frame the question also.
May I answer that? Exactly.
That may
shown from the record.
Yeah, we took your point that the question
Exactly
itself is
same question was asked.
in an earlier paper.
Yes.
In JE.
No, same question was asked. So he cannot act in census.
So there is a system of last 10 years papers and all that.
It is implied last census.
That's the question. In a good laptop appearing. One more. Because in 14 page 14 of the OA, just noted, they have quoted a question relating to an algebraic equation. My lads have put a query that it is very obvious that how can there be multiple answers to that? Because they themselves stated in OA what has happened in this question paper is given in multiple languages. In Hindi, there was a mistyping, 141 was typed as 114. And therefore, those students who had opted for Hindi and had read the Hindi question would not be able to arrive at the correct answer. Were not able to arrive at the correct answer. It's then
Yeah, that
What is it?
The question is there. I am saying.
Okay.
The problem here, even assuming my learned friend is correct, if it is a problem that is only for Hindi speaking,
Hindi opting.
yes, your lordships, but it has been awarded to everybody indiscriminately, your lordships. I can sleep in the paper and the paper is in English, but I will get a mark for that.
Para 14.7 of this advertisement says, let's CHSL 2022. Whether it says if there is any discrepancy between the language, English language shall be.
Apart from
Anybody attempting the
in an exam with negative
not in the
marking,
exam.
in an exam with negative
even in
marking.
the statute, Lord. It is published notice both in Hindi and English. It is written there, in case of any discrepancy, English will prevail instead of Hindi.
My lord,
That is what the regulation.
my lord, this is not case of applicant, my lord, any violation of the scheme of the examination, my lord. My lord, once the scheme of the examination is not.
We are not challenging
My
this.
lord,
No, they are not
my lord, second
Chaliye, okay,
My lord, second aspect of this case is that, my lord, second, one most important aspect of this case is that, my lord. Once they participated in tier 1, my lord, and they were successful, my lord. So can they raise the queries on the second part, my lord?
These questions are of tier 2, na? These questions are up from tier 2.
My lord, we will complain to you with this government is my house,
So
not.
they have to be heard.
The successful candidate has done their examination. They have given.
But that High Court order covers
Because in an
it.
exam with negative, not answering is also a conscious choice which a candidate takes, and therefore the benefit to all.
चलिए ठीक है ओके अब वो जो खड़े हुए
If you office one, otherwise it is really required.
Yes, and there is the written submissions. Both sides.
Both sides.
okay written submissions within 1 week 10 days within a week
Within a week,
week huh? चलो orders are item 131
तो आए ना बाहर से आए हैं आप लोग आए ना बाहर से
इनकी फाइल निकाली
क्या बाहर से आए
मैंने हमने तो बुलाया नहीं कौन लोग हैं आप लोग I'm for the respondent number 4 MCD और ये लोग कौन है as per the order stated